Hello and welcome to this episode of Scrutiny, my weekly exercise where I speak to people, do deep research, go through documents, and try and give you information which is beyond the information that is there in public domain. This is merely to ensure that whatever we are saying is backed by documents that we have and to further deep dive and bring more clarity on issues that are of significance and matter to Goans. I am Shujoy Gupta and you're with Inc. Goa. For quite some time now, we've been talking of Mr. Vishwajit Rane, the TCP minister's quote unquote Green Guardian Act of converting large tracts of land, and I'll get into figures now, back into no development zones because this is his way of giving back and showing that 39A of the TCP doesn't only work one way and convert land from no development parcels into settlements, but it works the other way around as well from so-called settlements and developable areas into no development zones. Today we are examining the absolute authenticity of that move and what lies within. So let's get into it right now. So the Goa TCP Minister, Mr. Vishwajit Rane, announced that about 1.23 crore lakh square meters, but we have records of about 1.45 crore square meters of ecologically sensitive land previously marked under settlement or various other zones being restored and declared as no development zones to protect environment and heritage. This was termed as an initiative to protect the land from settlement, and it spans multiple locations across the state of Goa. Now, a lot of researchers and environmental activists got into it, so I'll just flag that a little bit before going into the deep dive that I did. Now, environmental activist and PhD student Tahir Narona actually described this as this is what Americans called a nothing burger, meaning there is nothing in the burger. Elaborating, he said, by my calculation, less than 1% of the land is said to be brought or converted from settlement to no development zone. Now, what he meant is that barely 1% of that land is actually going to be converted from settlement to no development, actually. Whereas 99% of that land which Mr. Rane proposes to convert to NDZs are not developable anyway, or they are protected by central acts anyway. So it's not that you are giving them the cushion or the whole protection of no development, they are protected anyway. So what he's challenging merely is the claim of greening Goa back again, because those areas were already greened. And we decided now to look into every or as many parcels of land and look at their current zoning to check whether this NDZ is really true or whether these lands are already protected. Now, for instance, out of the 1.45.22 lakh square meters that Mr. Vishwajit Rane is taking out of NDZ, and this is the record we have, so we are quoting this figure 145.22 lakh or 1.45 crores. This is, we have data for this, that's why we are quoting this figure. Now, Mr. Rane is taking this area out of development as per gazette notifications that we have and preserved for future generations. But out of this 1.45 crore square meters that Mr. Rane is saying he's giving back to Goa as a part of a green initiative, the biggest parcel is of 65 lakh square meters. Now, this 65 lakh square meters comes from the Wagiri Hill in Sattari, and the entire Wagiri Hills in Sattari already falls within the buffer zone of the statutory Mahadev Wildlife Sanctuary, which means that it is not Mr. Rane's largesse that Wagiri is getting protected, this land was anyway protected or is anyway protected because it falls within the buffer zone of the statutory Mahadev Wildlife Sanctuary. So that whole claim is cut down by half with just one parcel of land that he's talking about. Because this is not protected by state law. Wagiri is not protected by any law or the law that the TCP is going to do, or the conversion that the TCP is going to do supposedly to NDZ. It is already protected by national law and the Forest Conservation Act. Now he made another example of the Grand Island or the South George Island in Mormugao that is being protected. Now again, that island is already a reserve forest and a separate law protects it. A separate state law already protects it. So you cannot do anything there anyway. Okay. So that is already a reserved forest. So what are you giving back by saying it's NDZ? It's not your gift anyway, no? So these are many examples of how this so-called protected land is being again given the category of NDZs and saying that the TCP is not protecting it. And this is where the disconcerting fact lies, Now, there are also other examples of many areas such as paddy fields that are actually protected from sale to companies and non-private individuals. These are paddy fields being cultivated by Goans. Now, many of these paddy fields have also been converted to NDZs, which means that once it comes under NDZs, now this conversion NDZs at any point of time, there may be a whim of the government or the minister that we'll convert them from NDZs to any other zoning. And those lands can again be sold to private companies, right? But when there are paddy fields as they exist now, they cannot be sold to private companies. So you are essentially converting paddy fields into so-called NDZs and taking away the protection that the paddy fields have from sale to companies and non-private individuals. Do understand this, and if possible, replay this to understand what we are trying to say. Now, let us now look at the detailed Google sheet, which will give you, and if you look at this graphic that we are putting up, it will give you details of the land that is being sought to be converted to NDZs, and more importantly, the current status of that land as it exists right now. Okay, so we will go through it one by one. Do bear with me, because since this is a deep dive, this is a scrutiny, and readers would find it well worth their time to just bear with us as we go through all these details to give you a better idea of the reality of these so-called NDZs. Now look at Perne. Okay, in the Mandrem village in the Perne Taluka, you have a land which is an orchard with no development slope anyway. Orchard with natural cover, part natural cover. That land already is under no development slope and partly of settlement. Now this land of about 8,30,000 square meters is being converted to NDZ. But this land already is under orchard with natural cover, no development slope and partly settlement. So this is not as if a completely settled land is being converted. Similarly, in Kankon, this is a land owned by, the name of the applicant is Vishant Prabhu Desai. Orchard with natural cover, no development slope, part settlement. Again converted to no development. In Mandre, Mahesh Desai, property owner. Current zone of that land, orchard, converted to no development, 1,79,000 square meters. Then you see Kankon, and you see all these in the graphics that are being played in front of you. Kankon in Loliang, property owner Vijay Gonkar. His land is already orchard, part orchard. It is a no development slope and it is only part settlement. 2,78,000. Again, we are told that it's going to be converted into NDZs, but this land is already orchard with no development, right? Now, what is very interesting is I'll give you one quick example of the Kankon land that we spoke of, owned by Vishant Prabhu Desai. Now, in that conversion, the government says in the note in the Gazette, it says leaving areas acquired by the government, meaning areas that are acquired by the government, they will continue to be acquired by the government, not converted into the so-called NDZ that they are talking about. Okay, so obviously you're converting, but the little footnote says leaving out areas. Now I'll tell you another interesting example. In Salvador Mund in Bardes. Now the applicant is not disclosed in the sheets that we have, but this particular land in Salvador Mund is orchard with natural cover, part, no development slope, and only part settlement. This area is being converted to no development when large parts of the area is already under no development with orchard with natural cover and NDS. This is 269,000 square meters. A very interesting footnote in this gazette says leaving area under settlement zone. Now, this seems to be a bit of a hoodwinking exercise because you're converting it into no development zone, but leaving a note that you have to leave the area already converted under settlement zone. You cannot touch that. So settlement will go on there. And other parts are under NDZ. But the funny part is that the other parts already are under orchard with no development. Already are under NDZ. So what kind of conversion to NDZ is it? You are already have areas under NDZ and you are saying leaving area under settlement zone, which means what is already under settlement zone, please don't touch it. That will remain settlement zone. And so on and so forth. Mandrem, another orchard with no development slope, converted to no development. 228,000. Cavelossim, 103,000 square meters, again converted to NDZ, but this is a cultivable paddy field and part orchard. And I was referring to the paddy field scenario. Again, Cavelossim, paddy field, cultivable paddy field with part orchard. And here you are converting this into no development, which means it will be open up for companies to buy it later if there's any other zone change. So that protection is gone. Chobde, orchard with natural cover, no development slope, partly settlement. 308,000 to be converted to NDZ when it is already orchard with natural cover and a no development slope. Similar case in Mandrem, another 211,000 square meters. Again in Chobde, same situation, orchard with no development slope and orchard with natural cover. This is the current status being converted to NDZ when this land already has protection. Okay, 264,000 odd square meters. Arambol, orchard with no development slope, meaning the land is already protected to be converted to no development. You're converting a no development area into no development and saying you've done a great thing. That is where my point is. 305,000 square meters, Arambol. Then we come to Pampurba. Pampurba, massive chunk of 912,000 square meters in Pampurba. The applicant is not disclosed in Bardes Taluka. Again, this current status of the land is orchard with natural cover, no development zone, part, private forest, and only part settlement. Repeat, it is already orchard with natural cover, part, no development, part, and private forest, part, and a part settlement. This has been converted to no development. But look at the catch here. There is a note under this gazette saying leaving area under settlement zone, meaning Baba, if this already under settlement zone, please don't touch it. That will continue to be settled, not converted to NDZ. And the image that you're giving, the picture that you're projecting is that you're converting everything into no development zone. And this is where the funny part is. Then again, in Osri, again same situation. Orchard with natural cover, part. It's in the irrigation command area. It is also under the no development slope, part of it, and part of it under settlement. Again, it says you convert this to NDZ. What is already orchard, irrigation command area, NDS is being sought to be converted to NDZ, giving it another name and calling it NDZ and giving a green cover to an already existing green cover. There is only part of the land that is settlement. And what does the noting say on this gazette? Leaving area under settlement zone. Meaning, what is under settlement zone, please do not touch, let it continue to be settled. The rest which is already protected is being sought to be protected again under a different name. This is my point. Then we have Majorda, same situation, cultivable land, paddy fields, command area, part settlement. Again, this is 250,000 square meters. Again, Majorda, you are again converting it into NDZ when it already is, it has sand dunes, paddy fields, and it's under command area. and you give a quick note there saying leaving area under settlement. Now, what are we trying to do? You are giving NDZ protection to already NDZ areas, and if those particular survey numbers have part settlement, you're putting a note saying leave out those settlement areas, don't convert them back into NDZ. This is the shocking part that has been unearthed by researchers and others. We have access to those documents. We've gone through this themselves. Gonsua, cultivable with khazan, paddy fields, command area, no development. Again with a note, leaving area under settlement. This is 1,95,000 square meters. Mormugao. Mormugao, I was talking of the Saint George Island. It's a reserve forest. It is already a reserve forest, and you are converting that into a no development. 6,63,000. Next, let's go to Keri. Now, this is extremely important. Keri is that Wagiri Hill conversion that I was talking of, the largest chunk. This is in Sattari, in Keri, and it has various survey numbers. Of course, there's no applicant mentioned here. This particular parcel of land of 65 lakh 31,752 square kilometers, it already is under natural cover, under NDZ, and completely in the buffer zone of the Madhe Wildlife Sanctuary. This is actually mentioned in the entire Gazette notification and in the documents pertaining to this. How can the minister be saying that you are granting so much of land back into NDZs when that area is completely protected anyway? This, you cannot re-protect an area which is completely under the buffer zone of the Madhe Wildlife Sanctuary, and no force on earth could have converted this anyway. So it is already protected. So on what basis are you saying that you are protecting this under no development zone when this is already protected? It is like saying I'm putting a lock in a house which is already surrounded and is almost like a fortress, and completely surrounded, fortress protected, and you're saying that you're going to put a padlock there and say that you have protected that land. That is exactly what it means. Now, and then of course there's one more parcel, Mandrem. It is about 6,44,000 square meters of land. Again, orchard part with no development zone. So this is, ladies and gentlemen, all viewers of Goa, this is something that we need to really, really look at, because as you said, what we are actually finding is this large amounts of conversion happening, and this conversion is not a conversion at all. Let me now summarize the points for you. For those of you who do not want to actually go through the entire list of conversions, supposed conversions to NDZ, let me summarize what these conversions actually mean. This is a shorter form of what I've already said. The largest parcel of 65.31 square meters, 65.31 lakh square meters in Keri Sattari already is under natural slopes. It is already under protection. It is already under protection because it's in the buffer zone of the Madhe Wildlife Sanctuary. That is one. In Pampurba, you have 9.12 lakh square meters, which already is under orchard with natural cover and forests and private forests. In Mandre, you have 6.44 lakh square meters of orchard land, which is already orchard. Now they are saying we're going to make it NDZ. So these are lands protected. Similarly, in Arambol, 3.05 lakh square meters, again orchard land, saying we are going to make it into NDZ. In Majorda, there are about 2.50 lakh square meters, again proposed under NDZ. And as I said, in that whole Majorda belt in parts of Cavelossim, there are paddy fields that are already paddy fields, cultivable only by private individuals. They are being converted to NDZ, and that cover of protection that they have under paddy fields is going. Similarly, in Gonsua, same situation, about 1.95 lakh square meters, and Cavelossim 1.03 lakh square meters. These are all land parcels that are being flagged as victory flags by the TCP minister, saying that I have converted these lands into NDZ and given them protection. The reality of this is that this protection, the garb of protection, is being claimed and tom-tommed when most of these lands are already pre-protected. Okay, and this is what the point is. See, again, this Cavelossim, I'd like to just dwell on this a little bit. See, if you look at Cavelossim, there the TCP has proposed the reclassification of land, mixed use land, including paddy fields, orchards, mangroves, and settlement areas. The local panchayat says there was no application made for such zoning back to NDZs. And the Sarpanch Dixon was actually criticized and commented on this whole unilateral decision making process. Who asked for this conversion? Because we already have paddy fields here. The TCP minister's reaction or defense of this is this move is a restoration and it is not a conversion exercise. He says his aim is to restore land to its original ecological status. And the government says fragile land and environmental sensitive areas need protection. As we have explained, that most of this land, 99% of this land, did not need restoration because they were already protected. You are not restoring land to its original ecological status because this was the status already there, and they are already under protection. It's not as if they are, all of it is under settlement and you are converting it back into no development zones and giving it protection. So they are already protected. So what are you protecting? And fragile terrain and environmentally sensitive areas need protection. Yes, they do. And I will not now go into how economically sensitive areas and fragile land, instead of being protected, have actually been converted and destroyed much earlier. And that destruction has already happened. Now, TCP Minister Vishwajit Rane, he rewrote Goa's little laws by bringing in section 17.2 and 39A. This particular act and what happened after that allowed builders to get in and grab protected land. It was called development then. High Court called 17.2 illegal and struck it down. We are now, because readers must know what has already happened. And under this whole garb of protecting land by making it into NDZs, I just like to flag for the benefit of viewers that land which was supposed to be protected has already been destroyed. What happened next after the 17.2? Many activists called it a scam, and it could well be that collapsed. The TCP quietly began inviting applications under section 39A. And this was done with the entire cabinet's backing. That is also clear. It was a cabinet decision that decided. And it basically allowed everybody a shot at zone change of their land, bypassing regional plans and public objections. Fast forward to October 2025. Now, in October 2025, there is data that there were over 1,000 applications for almost 1 crore square meters of zoning changes. 118 applications were received for 7 lakh square meters. Out of this, 7 lakh square meters of Goa's land was already approved for conversion. And this was done in hurriedly convened weekly TCP meetings. So, let us not forget how land was destroyed through these conversions. 118 zone change conversions were granted up to 2025. Yeah, so the total, I said 7 lakhs, the correct figure is 6.88 lakhs, little less, but orchards, paddy fields, hillsides, other lands, all of this were converted. June 2025 also, now coming to June 2025, earlier, the TCP board approved conversion of 1 lakh square meters under 39A. In July 2025, TCP approved another 29,700 square meters under 39A. This again in 2026, this issue resurfaced with 70,000 square meters of land proposed to be converted under 39A. Now, this is what we are trying to say. And the land converted, fields, orchards, natural cover, they are all settlement zones. 95% of these approvals are for non-Goan builder lobbies, less than 5% are for Goans. Do you want to know some of the companies which have benefited from this? Enigma Properties in Ella Tiswari, Maybury Estates in Korgaon, outsiders. Of course, Rajendra Malik in Bicholi, we do not know. 79,000 square meters. Green First Estate Private Limited is the company. PV, 1 lakh square meters. All of this. And once this happens, conversion happens, pressure is put on the panchayats to issue construction licenses. This is what is happening. Goan signatures are legalizing these builder empires. Goan signatures. This is destroying Goa. Goans must track every punch member who signs a 39A construction license because Goan hands are a part of this destruction. This is monetized manipulation. Already so much of destruction has happened. Can we forget that and believe in this bogey of conversion to NDZs? Is Goa really green? Do we have green guardians or do we have green destroyers? Goans are selling Goa. And what is important here is, and I'm not blaming everybody, I'm blaming people in government who are probably helpless, are participating in this loot. Goan panchayats are signing off construction licenses for profits. So unless this 39A is repealed and accountably demanded, let us not fool Goans with these promises of converting so much into NDZs, when NDZ is not even a term under the TCP. In any case, will be challenged. No development zones is not a term. It is not even a term. This comes under CRZ. It doesn't come under this. So again, you are playing, you're introducing elements that are not legally tenable right now, and these are things that need to be asked. So before we end, this was all about data. This was all about putting it out there. This is all about telling you the real story behind NDZ. And what is being actually destroyed is not just Goa's land, but Goa's soul. And let us be aware of this. Thank you very much.